As they say, good evening. Better late than never. Not legal advice. Like, subscribe, share. If you're here, greetings. If you're not here and you see this later on, greetings to you. Hope everybody is well. Going to talk about a few things. Figured I'd try a different time and different mode and see who is willing to be here at this time. If it's Friday, good morning. If it's Thursday, good evening. So before I begin, I got a bunch of topics to talk about. A few little points here. The prisoner was told by his attorney, I have some good news and some bad news. The prisoner said, how about the bad news first? The attorney says, they found your blood at the crime scene. The prisoner then asks, what's the good news? Your good news is your cholesterol is 120. I heard the EU has 1 GB of free space left. The fact that it would be hilarious if someone got elected president is not a good enough reason. We should have known that communism was going to be bad because of all the obvious red flags. And last but not least, isn't it interesting that we have 2 candidates for president, but 50 for Miss America? Anyway, wanted to talk a little bit about Alpine, Curt Kramer, the proceedings that are going on against Kramer, and a couple of matters involving the Supreme Court that happened today that came out decision. One regarding arbitration, which made me think of Mmtlp, and another with regard to the Consumer Financial Protection Bureau and their ability to be funded. So I'm going to kind of quickly go through those. Hopefully that will deal with those issues. So first I'm going to talk about Alpine. Someone was asking about the status of the proceeding against Alpine through the NSCC, the DTCC. They were curious about who was being impacted by that decision and when. So Alpine was expelled from the DTCC, NSCC, the end of April of 2024. What happened is that decision has been stayed by something called an administrative stay through the SEC. So they've automatically stayed the decision so it doesn't become effective. At the same time, Alpine has asked for a stay formally in a motion. So what will happen is this appeal is now before the SEC. They will make a decision on the stay. If they don't order a stay, and a stay means that everything is stopped. If they don't order a stay, then Alpine will then go to federal court and ask for a stay. Because of the circumstances, at some point in time, I would expect them to get a stay so they won't be expelled currently. So what's going to happen is there will be an appeal that's heard before the SEC that'll be fairly quick, that'll occur pretty quickly, generally, less than 6 months, could be faster. And if they lose that appeal, which I'm sure they will, then that will go to the Court of Appeal, federal court, and they will issue the final decision. And when that's issued, let's assume it continues on, at the end of that proceeding, Alpine is likely to get expelled. So the death sentence that they're facing is likely to be imposed at that later moment. And I'll keep you apprised of the dates, but that's what's going on. So they were expelled, but the expulsion has not been enforced. So that's Alpine. Of course, there's the DC appeal involving FINRA that's ongoing. The briefs were submitted about 45 days ago. A decision will probably occur within the next 2 weeks, and that will be with regard to the ability to expel Alpine by FINRA. And obviously the relevance of all this is some people believe that Alpine has a concentrated short position in Gtii, that our famous stock, or one of our famous stocks. And some people believe that Alpine is suspended, expelled, that will trigger some events. And obviously there's been a lot of activity in the last few days, so it'll be interesting to see what would happen. But that's kind of the status of Alpine. Since I'm referencing Gtii, I might as well continue. I'm involved in putting together, or at least collecting people who are interested in moving against management. As of this point in time, I think about 250 people have reached out with interest in getting rid of management of Gtii. Now, a lot of people look at Gtii, and some people focus on potential short squeeze or raises by that. Some people look like me that it could do business. So I'm focusing on the fact that it could do business. There are many suitors. In my opinion and opinion of others, current management hasn't done anything to further the interests of shareholders. And that's what the collection of people are interested in pursuing. So if anybody out there is interested in pursuing Alpine management, is interested in the change, feel free to reach out to me. You can reach me at Tesla, TESSLAW 420 at gmail.com. Feel free to email me there, and I will provide you information about what's going on with regard to management or efforts about management. And I think I'm optimistic that those efforts will be successful. I'm optimistic, no guarantees, of course, that Gtii management will see different days, and that once Gtii management is on to some other things, that new management can come in, close a deal, move forward, and that all shareholders will benefit. And I think that's hopefully in the cards, although obviously not legal advice. Like, subscribe, comment, do your own due diligence, but that's just my opinion. And apparently, since I've been contacted by a lot of people, that's the opinion of a lot of others. So that's the current status of Gtii and what's going on with that. I briefly wanted to talk about the Kramers, Curt Kramer. So everybody knows, or I don't know if everybody knows, but there was a complaint filed against Curt Kramer by the SEC. Kramer is one of those notorious shorts. Had a couple of prior instances where admitted to wrongdoing, I think in 2013, 2016. The current complaint is for 2018 through 2023. I think it involved purported profits of $75 million. It just began this proceeding. So the way it goes, and just to kind of reiterate what happens, complaint was filed. That starts the proceeding. It's then served on the defendants. In this case, the defendants are Curt Kramer, Power Up Lending Group, Geneva Roth, Remark Holdings, and 1800 Diagonal Lending, LLC. So all those parties will be served with the complaint. Then they will have an opportunity to respond to that. They'll have 21 days to file a response. That could either be an answer or they could challenge the pleading. If they're in here for the long haul, if they have no intention of resolving this matter, now I'm referring to the Kramer clan, then they're going to obviously fight this proceeding. So this proceeding happens to be in federal court in New York in the Southern District. It has multiple claims for relief. In essence, it's going to ask for the return of $75 million in profits that were made and other fines, etc. But that $75 million will be the most significant aspect, I think, of this complaint. That compares to the two prior instances. I believe in one, Curt Kramer, Curt with a C, Kramer with a K, he agreed to pay something on the order of $1.4 million in profits. And the other one, it was something on the order of $500,000 in profits that were returned. So the $75 million is substantially more than any of the other prior admissions. I looked on the court site, and as of today, all that has happened is that the complaint has been served, has not been responded to. I think it was served on or about May 8th, so we have some time, probably to the end of the month. That time period could be extended. I looked at and found the attorney for the SEC that's representing the SEC in this matter, and his name is Daniel T. Lloyd. I reached out to him today and will continue to, And the one thing that I wanted to make clear, because I've heard other people reference that, is they want to make sure that Kramer, Curt with a C, doesn't just get off with a fine. And I am going to clearly communicate that to the attorney for the SEC. I've already emailed, called, left a message, and I'll continue doing that. I don't advise everybody else to do that at this point in time because they might get annoyed by that. But I intend to do that and intend to make sure that retail's interests are communicated to the counsel for the SEC. Hopefully that will be valuable for everybody else. To the person who asked about any good news for GTII, yes, we're proceeding. We're proceeding to proceed against management to get them out. I'm very optimistic that that's what will happen. And it's been a very popular idea for many. So even though today we're not done, look forward to more progress. So flipping back to Kramer, depending upon what they intend to do in terms of how much effort and money they spend on defending themselves, that will determine how the case goes. If they get out of business, because there was that case recently with the accountant Borgers, the SEC went after them. They put them out of business. That was the agreed ending. They were fined, I think, something on the order of $12 million, and the principal was fined $2 million. The problem in the current case is because of the amount of the profit at issue, the fine would have to be enormous. So I just can't imagine Kramer, Curt with a C, would agree to that. But we shall see. And again, I will follow up on that. There was a couple of interesting decisions that were announced by the Supreme Court today. One, Smith versus Spizzirri, Spizzirri. How would you pronounce that? I think it's Spizzirri or Bizzarri. That was a case under the Federal Arbitration Act. And the question was, when someone, and the reason why it caught my attention, one, because it was a Supreme Court case, that was the decision that was issued today, and there's probably only been about 15 decisions that have been put out yet in this term of the Supreme Court, and it involved the Federal Arbitration Act. And I'm in arbitration against Mmtlp. I'm after Fidelity in a arbitration, so I was interested. And it turns out, sounded to me like it was interestingly similar to my situation. So in this case, there was a employment situation. There was an arbitration clause in the employment situation, which required them to comply with the Federal Arbitration Act, which provides some modicum of due process, theoretically. And one of the parties, the plaintiff, filed an action in state court, like I did. I filed an action in state court. That's where I first started. The defendant then removed it to federal court, just like it happened in my case. In federal court, although someone asked for a stay, the court dismissed the action and sent it to arbitration. The appellate court, the Ninth Circuit of Court of Appeal, so it's out here in California, ruled that was okay. The case went up to the Supreme Court. The Supreme Court said that the action is supposed to go on until there's been accordance or agreement or actions that are in accordance with the terms of the arbitration agreement. And that's what's supposed to happen. And in the meantime, until that happens, the underlying action should be stayed. There should be a stay, not a dismissal. And in this particular case, after the arbitration was begun, the district court dismissed the case. So the Supreme Court said they shouldn't have dismissed the case. They should have just stayed it and held it. And it would have had some value, or it might have had some influence. So in my case, it's exactly what happened. The court dismissed the case. They didn't stay it. So I believe that my arbitration might be covered by this new Supreme Court case. And what's interesting is, so the guidance here is that there's supposed to be compliance with the arbitration agreement. So what happens if there's not? So what happens if you go through an arbitration and the parties that are supposed to be conducting the arbitration violate your rights in the way they conduct the proceeding? Perhaps they don't give you proper due process, which I would say that happened in my particular matter. So if they don't comply with proceedings, does that mean that when the court says and finds that you don't have to go through another arbitration? Because what happened in this particular case is after the Supreme Court makes its decision, it sent it back to the trial court for further proceedings. So let's say, for the sake of discussion, I'm in my Mmtlp arbitration, the court rules incorrectly and then finds that the arbitration was not conducted with proper due process. Does that mean now that I don't have to comply with the arbitration clause and I can just go after and sue the SEC, Fidelity, whoever directly? It would be Fidelity in this case, without worrying about arbitration. Left it unsettled, but created an issue about that. And with regard to Mmtlp, I'm involved. And Mmtlp is apparently tied in some way to the Trump stock, and Devin Nunes is trying to push for consideration with regard to DJT, which is the Trump stock. And in one of their submissions, they attached a letter, the congressional letter about Mmtlp, in one of their submissions. So it's interesting because people are waiting, and I heard today, people are waiting for the announcement of some type of hearing, and people think that if there's a hearing announced, that it might benefit Mmtlp. And so I'm waiting for that too, because I can use all of that in my arbitration, and that's what I intend to do. We are still in a battle, by the way, in the arbitration over the arbiter. There is a motion pending, and we're set for hearing in basically a trial in about 30 days. But we're still in a discussion, an argument about the current arbiter. And as you recall, the reason why I tried to get rid of the current arbiter, and I've kind of made it well known, because I've talked about arbitration, and this is the arbitration that we're all required to go through if we sign a customer agreement, and almost all of them have an arbitration provision, and you have to go through the same type of proceeding that I have gone through, which I've kind of made clear so people understood what they were going through. So right now, we're still arguing about the arbiter. And in this case, we're arguing about discovery, because discovery is limited in arbitration. And whatever discovery I requested was denied. And it wasn't, that could include like a share count. That could also include the names of witnesses at Fidelity who worked on Mmtlp. But that has not moved the arbiter. So what was interesting to me, despite multiple requests, the arbiter has not held a hearing, has not given a reasoning, has not considered the claims, does not have expertise in litigation, apparently gave the wrong office address. So in other words, when we started this arbitration, he purported to be in an office and having an active practice when he doesn't. He doesn't have an office, and it appears he doesn't have an active practice. And it appears that he was somewhat deceptive. That's my view. And those are the reasons, amongst many, why I've asked that he been recused. I also sued the arbiter to make sure that he doesn't get any kind of compensation based upon the way he's handling the matter. That must have been significant to FINRA, because FINRA's general counsel's office reached out to me, and I think that was about 3 days ago, to confirm that the lawsuit was served on the arbiter. I provided them a copy of the proof of service, so now they're aware of that. The fact of the lawsuit in of itself doesn't create a conflict of interest that would exclude an arbiter. So if that was the only reason, if I sued the arbiter, it's obviously a conflict, because then that person's ruling against you. But if that was the only reason, they could say that that's not enough to get rid of the arbiter. But in this case, I kind of laid out a bunch of reasons, including the fact no review, no hearings, no rationale, no nothing. I don't know what the arbiter's doing, to be quite honest. And that's where we stand. So in the arbitration, we're a month away, but we haven't even figured out who the arbiters are going to be, or if there's going to be arbiters. If in fact we have to go forward in the arbitration with the current panel, obviously that will be an issue that will be brought up in front of the federal court if in fact the arbitration award has to be confirmed. So the way it goes in arbitration, you have an arbitration, you get an award, but that award is not enforceable unless you get a court to issue a judgment or to confirm the order of the arbiter and then issue a judgment. So in this case, let's say the arbiter issues an award tomorrow, then somebody has to file a motion to get that arbitration award either enforced or vacated. So there will be proceeding in federal court, assuming, where the underlying arbitration, everything that went on, including all my complaints about the process, etc., will be heard before the federal court. If the federal court doesn't think, well, depending on the outcome, hopefully we win in the arbitration. I'm just somewhat skeptical based upon the way they're handling things, but I have good witnesses and good testimony, and we shall see. But no matter how it goes, there'll be a hearing in federal court and all the proceedings will be laid out. The federal court will either say it's adequate or inadequate. Depending on how it goes, if the award is against us and it's confirmed by the federal court, then we will take it up to the Ninth Circuit Court of Appeal. And one of the things we will point to is that Supreme Court case that I mentioned, because the district court in my case, according to the Supreme Court, made the wrong ruling because it dismissed the action, should have stayed the action. And all of the procedural irregularities that I've pointed out will be pointed out to the federal court. Based upon that, they will make a decision. And again, I thought when I filed the arbitration, it was possible that we would go up to the Ninth Circuit. The benefit of going up to the Ninth Circuit is we could make law in the Ninth Circuit Court of Appeal. So if we find that the arbitration process as handled was done improperly, we might be able to get the Ninth Circuit to create law and give consumers more rights. In the meantime, we have to see what happens with DJT and if Mmtlp is involved and attached as it has been to this point in time, because if whatever good comes out of it will be before the arbiter, kind of providing documents as they come out on a daily basis. And hopefully this will help everybody in the future with regard to arbitration. Obviously, I think it's ludicrous that we all, as consumers, are forced to go and arbitrate within a system that's stacked against us. And one of the measures that needs to be evaluated is the arbitration procedure that we all have to face. And there are plenty of contracts that have arbitration clauses. The question is, are we getting due process? And are we be treating fairly? Unfortunately, there are sometimes things called protected classes, and they're entitled to certain protections, like you can't discriminate against on race or religion, etc. And if you do so, those classes have certain protections. Unfortunately, retail investors are not a protected class, but they're just as at risk as anyone else from all the other institutional entities practicing. And I think they should be provided certain protections that they're not. And certainly that should be with regard to arbitration. I don't think arbitration should be, as in the current form, should exist because most customers, most clients, most shareholders, it's either too expensive, too time-consuming, too costly, and just too difficult to do. Not fair. It cuts off all your remedies, because what happens if you're not able to go forward with arbitration? What other remedies are you left? So I'm hoping that part of whatever we do to change the system includes changing the remedies and the processes by which consumers can get remedies. and hopefully that will occur. I'll keep you apprised, obviously, of the arbitration since we're getting very close, and I'll keep you apprised of what happens with the arbiter and all the proceedings involving the arbiter. The other case that came out today, just briefly, that kind of struck me was involved the Consumer Financial Protection Bureau against some, I guess it was some services that were suing them over certain new regulations that they had imposed. It was, I guess, trade associations that had sued the Consumer Financial Protection Bureau for new rules that impacted them. And basically, the response was that the way they were funded was inappropriate constitutionally. So they challenged the rulings based upon the funding of this particular agency. And again, it reminded me of the ongoing cases that are in the Supreme Court. There's one involving Gtii, which is the SEC's internal legal proceedings and procedures they used, and their judicial branch, and was basically trying to impact their ability to conduct proceedings in the future when they're going against members. And it's designed, or at least the Gtii side would like them to go into federal court. So there's several cases that are challenging or attempting to challenge the ability of either federal agencies or SROs to conduct business. This particular case, even though it doesn't involve the SEC or FINRA, is another agency and a challenge to the agency's ability to go forward. And the Supreme Court, in a majority opinion, held that the funding of the Consumer Financial Protection Bureau was adequate, was not restricted by the Constitution, and they allowed the rulemaking of the Consumer Financial Protection Bureau. So I'm taking this as a preview in Gtii in the actions against the SEC, and it might apply to future actions against Alpine and FINRA. And there's actually a couple of lawsuits that are pending against FINRA challenging the constitutionality of FINRA's ability to adjudicate claims. But it was interesting, this particular decision issued today found for basically the government. So the fact that they found for the government made me think that cases like Gtii involving the SEC, and perhaps later on Alpine involving FINRA, and other two cases that I think are pending that might go to the Supreme Court, suggesting that the Supreme Court might back up the ability of the SEC and FINRA to conduct hearings, or to conduct hearings in the manner they do. But we haven't yet seen the ruling in Gtii, and obviously the other cases haven't got to the Supreme Court. Gtii was heard, I believe, either very early 2024 or late 2023. The ruling will come out in June, and it'll be interesting to see how it plays out. And I'll obviously keep you apprised and let you know how it does impact us in terms of our stuff. So just to kind of go through the stuff that I referenced Alpine and the current status of the proceedings to expel them before the NSCC and DTCC, and that it's currently stayed. I referenced the DC proceeding, which we're waiting for the ruling of the appellate court to expel them by FINRA. We'll see which one happens first. But as I've said many times, no matter how it ends, it's going to end. And Alpine is going to be DOA at some point in time. It's just a matter of time. The question is, will it trigger activity in GTII? Will it trigger positive activity? Will we need to wait to the end for that to occur, if it's going to occur? In other words, some people believe that Alpine has to be completely dead for that to trigger a short squeeze. I don't know if it's going to trigger a short squeeze, but I also don't think it necessarily has to be dead. It could be just some ruling, could be some other event that triggers shorts to cover. And we'll have to see that, because there's a concentrated short position, although some people have expressed, because I've received some comments some people have expressed dissent about whether Alpine actually has a concentrated short position, notwithstanding what it says. But we'll have to see how it plays out. But again, my view of the Alpine scenario is GTI can run on its own business, and if it brought in revenue, that would generate it. It would generate, I think, an impact on the stock price. And just to go back through that, GTII, there are people who are interested in removing management, and I welcome them to reach out to me. And there have been approximately 250 investors that have reached out, and the more the merrier, and I welcome that. And we talked about Mmtlp and the arbitration, where I am with my arbiter, the main arbiter. Again, it was one of three. And then I referenced a Supreme Court case that seemed to provide perhaps some support in the future, protecting our arbitration rights. And then I also referenced some case that was decided by the Supreme Court where they validated one of their agencies. And I analogized that to maybe the cases that are out there involving the SEC and FINRA, but we shall see. I agree, by the way, and I'm going to put this up there because I agree with this statement, that Alpine is horrible. I agree. They should be out of business, in my opinion, and hopefully they soon will be. So that's it. That's all I wanted to go through. I welcome anybody who has interest in GTI to reach out. If you have questions about Alpine, if you have questions about Mmtlp, if you have questions about the Supreme Court decision, or either of those Supreme Court decisions, if you have questions about how arbitration works, anything like that, please reach out to me, comment, put out questions. I promise to look at all comments. I always do. And I always indicate that I've looked at your comment, and if I can answer in a coherent way and give you some answer that answers your question, I certainly will provide it. I'll try, even if I can't. Anyway, that was a quickie. I just want to do a quickie. I could have done this in a video form, but I decided to do it in a live form, even though it's very late at night. Will a lawsuit hinder us from having a potential squeeze? I'll answer that question. My concern, this is just my opinion, my concern, and I assume you're talking about GTII. My concern is that if people don't act on GTII in light of what I see, this is my opinion, of what I see as looting of the company in 2023 in particular, and I would guess ongoing, I don't think if there wasn't action taken, I think that the company would have a chance of not surviving. And I think the only thing that will keep the company from not going out of business is by removing management. And so the way I see it, a lawsuit will not only not hinder a potential squeeze, it would potentially enable a potential squeeze. And I know that people were waiting, but kind of as I went through where we are in Alpine, and I follow it very carefully, we don't know when that's going to be over. They're going to be, I guess I should address that. So, there's appeals in the matter that's against the NSCC. There's an appeal to the SEC, and then there's an appeal to the Court of Appeal. That's notwithstanding the stay that I mentioned. So I mentioned it was stayed, but that there's still going to be an appeal hearing before the SEC, and then they will take it up to court. That'll probably take another year or so. Could be longer, could be shorter, more likely to be slightly longer. And then there's the proceeding in DC where there's a quote unquote, the expedited expulsion, but that hasn't been completed yet. And then there are at least 2 more rounds of appeal before that. So they could, excuse my language, they could dick around there too for quite some time. So it might take a year or 2 to get them out. Although something might happen before that might do that. So in my opinion, a lawsuit to get rid of GTII management is the best way to expedite the advance of GTII. And as I mentioned, notwithstanding whatever the status is of GTII, there are numerous, or at least I should say, I should say this. I've been contacted by numerous suitors, various people, all interested. And, in light of GTII's status, you might wonder why they are interested. They're interested because there is a shareholder base that is a dedicated shareholder base, and all of them unanimously have mentioned that. And there's a concentrated short position. So they all want to do deals. And in these deals, and I don't know, I'm not talking specifics here, but in these deals that, let's say they get 20 million shares, they may think those shares might go up in substantial value once they bring revenue to the company. So the long answer to that is, I don't think it will hinder. I think it will encourage positive movement in the stock. And so that's why I'm for that. And beyond that, ethically speaking, and the reason why I've been pushing for it, I've been dealing with management directly, or trying to deal with management, since the very beginning of February. And they have been completely, since March, I think March 18th, they have been completely non-responsive, put out things that were inconsistent with what was represented. And the 10K, if you look at it yourself, is full of information that would cause anyone to be stunned in disbelief. And I don't mean that in a positive way. So that's why, I'm hoping that the litigation is successful. And I really do feel, and again, it's not legal advice and it's not just opinion, but I really do feel that is the way to go. And otherwise, I wouldn't be recommending it. And I understand everybody's concern about that. I saw the question about Northwest Bio and Citadel's horrible, and Ken Griffin. I can only agree with that. Northwest Bio is like is one of those situations where a company doing good work on, I think it's glioblastoma, I believe, brain cancer, is doing good work on trials in that area, and they're being shorted and tried to be put out of business by others. And I found that, by the way, is one of the things that interested me, is when I started looking at, and I followed Ham and all those people, and then I started independently to notice other biotechs that were shorted, and I found that just to be so unethical. I don't understand why it's even allowed. I think one thing that should be done is that, in terms of medical companies, and I don't know others, there are probably other classes of companies, but you shouldn't be allowed to short companies that might save lives. I just don't think that's an ethical way of proceeding. Northwest Bio is a company like that, but there's tons of biotechs that get hit. And the reason they get hit, because they have to raise money, because there's a 3-phase trial program. So I really think that in general, and Northwest Bio is a good idea, that those companies should be protected. And originally I got involved, or looking at it, was with Sava Therapeutics, Sava Sciences. SAVA is the symbol. And that was a company that was working on Alzheimer's, a cure for Alzheimer's. And I didn't know much about the short market when I first started there, but I noticed that there were these short reports that would be put out at very opportune times to impact the stock, and they would always do that. And there was a question as to the validity of those short reports. And that's one thing that there's very little, in my opinion, regulation or control over. And I understand there's a First Amendment right to speak and put out what you want, but there are short and distort reports that are put out. They have their impact as soon as they're put out. In fact, there might be an algorithm just looking for words. So they might put an article out, and the algorithm will pick up the words in the story. It'll immediately impact the price. And it's almost impossible to undo that. It happened in case of finger motion. The stock had risen to about in the 7s. Capybara, who's gotten into trouble with, I think, with Mark Bazile and in court in New York for putting out fake reports, which they really didn't defend against, but they put out reports at opportune times at the near high of finger motion, and finger motion dropped. And I think the company lost hundreds of millions of dollars in market cap just because of that fake report. And there's no way of collecting that money. You can't go after anybody and collect that money. They don't have any money, or they're offshore. Like Capybara, I think, was somewhere in Asia or South America. And even though you could get a judgment against them, you couldn't enforce them, and tomorrow they might be Crappy Bear, a new company name, issuing short reports. I really think there should be enforcement of these reports where you can establish they're intended to harm companies. Because, as I said, the problem with that is those kind of things are protected by the First Amendment. You have a right to speak, you have a right to write, but you can't do it with the intention of harming someone, because that's different. It takes into a different class of acts. So you might be allowed to say something, but you also might have the ramifications of saying that. And again, that's what finger motion was inflicted by. And I really think there should be regulatory, and again, we're talking about the regulators. And I heard Patrick Byrne, I think yesterday, the day before, I agree with his comments that and I'm summarizing what he said, but he basically said the regulators were worthless. You couldn't trust them. He also said, in his dealings with Congress, he didn't find them to be helpful. He found the whole system to be worthless. And I have to be honest that in dealing with what we've seen to date, I would say I would criticize the hedge funds. I would criticize the brokers. I would criticize the regulators. I would criticize the legislators, and I'd have to criticize management in some point. So if all those things are deficient, then this is pretty tough, right? Pretty tough to get it done if every aspect of the financial game is corrupt. And what is good about the current movement is that corruption is being brought up front and being exposed. And eventually, I don't know how long it will take, but with additional exposure, we keep on hammering it home, eventually we'll be successful. And I believe that we should hold congressional representatives and senators responsible. To the extent they let this stuff go on, I think they should be targeted in the future. That's my opinion, my personal opinion, that the ones who support the interests that are against retail should be called out. They should be called out on the mat, and they should be voted out of office. And to the extent that there are whistleblowers out there, and there's got to be whistleblowers out there, to the extent there's whistleblowers out there, first of all, I would love someone to contact me if you have information about Mmtlp or Alpine or Gtii or finger motion. But even if it's not about any of those tickers, if you're a whistleblower out there, go and whistleblow. Blow your whistle. You can make tons of money, but you can also do retail a big favor, and you'll be a hero. I can imagine that for a whistleblower, and it happened I think with Boeing, may have been perfectly legitimate, but recently a couple whistleblowers at Boeing met untimely ends. And they were talking about, I'm sure a lot of you are aware about the problems that Boeing has had with parts falling off in flight, and claims about improper parts being, used on planes. And there were whistleblowers that came out. Two of them mysteriously passed away recently. So hopefully there will be whistleblowers who stand up. And in this case, honestly, for a whistleblower, either go for the money or go for the having done an excellent thing for the rest of society. I know there are people out there that are interested in doing that. Perhaps they've reached out. I'm sure they're frightened because there's a lot of money involved, and so I'm hoping for that. I see there's a question. I appreciate the question about the 10K. Gtii did file their 10K on April 16th. Just it wasn't a very good 10K. I appreciate the question. One of the issues that came up was in my conversations with counsel for Gtii, they promised in writing to have it done by March 31st. When March 31st came, they didn't file it. On April 1st, they filed an extension. On April 16th, they actually filed a 10K. The 10K, in my opinion, was a disaster, and that's why we're seeking the removal or the change in management. I know, by the way, in NextBridge also, and by the way, what's interesting about the 10K was the prior financials, 2022, 2023, and probably in a lot of companies, were undertaken by a company called Borgers Accounting, and that's the company that was basically put out of business by the SEC this week. And it did a lot of small companies. One of them was Gtii, which is interesting because the chief financial officer, CEO, and chief accounting officer is the one who decided to use Borgers. So it wasn't like somebody who wouldn't know what they were doing, at least in my opinion. So in other words, if I hired a lawyer to work on a case involving something that I was an expert in, I would expect to know what was going on. As it turns out, the CFO, CEO, and chief accounting officer, who also had a tax practice, was David Reichman, who was the head of Gtii. So if he didn't know what Borgers, his auditor, was doing, that would be surprising. And it's concerning also, just the content of it. Anybody who reviews the 10K will find it interesting. And what's also interesting is they didn't fire the auditor until very recently, which caused me great concern, because then they issued a PR, and it was this week, where the new COO, Mr. Rabari, referenced that how quickly they had moved to hire a new auditing firm, which they did. I think it was Fortune was the new auditing firm. But they hired them after their prior firm had literally ceased operations. So it wasn't like they could do anything. And what's also interesting, by the way, just speaking of the PR while I'm thinking about it, was it referenced, besides the fact that they had hired a new auditor, but they had reaffirmed what had occurred in the financials. So basically what they said is, yeah, we hired a new auditor today, and we reaffirm the content of what happened in 2022 and 2023 in the financials that were made. What's interesting, but they also say that they agreed to reserve the right to go after the former auditor for misconduct. I found that a really odd statement. I found it especially an odd statement when David Reichman was monitoring all that. What's also interesting, so they got rid of Borgers in May, and what's also interesting is NextBridge also had Borgers, but they got rid of Borgers in February. So they acted, and that's before Borgers got kicked out of being able to operate as an accounting firm just this week. So it's interesting that NextBridge got rid of them, whereas Gtii waited till they were kicked out of business by the SEC and then graciously and immediately hired somebody else, even though their CEO theoretically would have been aware of all the content of all the financials that occurred to date. So I find that interesting. Somebody asked about the new CAT system that's going in on May 31st. I hope it really works. I hope that there's no litigation that pops up before that. My concern is, because I understand that Ken Griffin and his company or companies or agents are bitching about the new CAT system. So one, and I appreciate that, that's Rudy Myers. Thank you for your comment there. The question or the thought I had is, and I think I posed that to somebody today, was I would expect somebody to go in and try to get an injunction to stop the enforcement of the system. I think their claim is going to be on some privacy grounds or other related grounds. I don't know if it's meaningful, but if they're really opposed to it, I would expect them to try to block it. And right now, I think they're probably lobbying Congress. When I say lobbying, so that means you call up Congress or you provide them incentives. You can draw your own conclusion. This is my opinion. But that's what's going on now. And I'm sure there's a lot of friends that Ken Griffin has in Congress, both in the House and in the Senate. I'm sure there's plenty of lobbying on, but my concern ultimately is that they go in and try to block it. I believe that the CAT system and any system that causes them to be more transparent is positive. So, and I would think that they would think it's positive also. I think also the T+1 is going to be excellent. It'll provide more liquidity for retail shareholders. It'll provide us because it really should be T+0 because any trade really settles electronically immediately. It doesn't take a day. Just like if you deposit money in a bank, it's credited the same. If it's your account, it's credited and it's valid. One, if it's cash or something equivalent, you get credit that same day. That's the way it should be for securities. Somehow they use it for whatever reason. One last thing I wanted to talk about, or I thought I was done anyway, but one additional thing that was interesting in Patrick Byrne's the spaces that happened yesterday that my friend Busy Brands ran with Curtis and Junk Savvy. I think we're running it. I think Kristen was there, Dennis Neal was there, and there were some other parties there besides Mr. Byrne. But what was interesting, and I've maintained this, that the biggest problem is really the share lending problem. He indicated that Goldman Sachs in his time was generating 75%, I think he said 75% of their profits through their share lending. And we have to understand how this works. So whether the shorts are legitimate or not legitimate doesn't really make a difference. There's share lending, and the share lending theoretically works against the interest of the shareholder because they're lending shares to shorts, and the shorts theoretically will suppress the price, whether they're good, whether they're proper or not proper. In the disclosures you get in your agreement, they don't tell you that. They might tell you that they might engage in some kind of vague transaction where it might be different than in your support of yours, but here they're operating directly to the contrary of your interest. And they're making most of their profit by doing that. It's not trading, it's by lending out shares and charging exorbitant interest. So what they do, and I've seen it already it's not on finger motion, but let's say that the interest rate goes up. So to borrow shares, cost to borrow goes over 100%. They might pay you, if you had an account, they might pay you 20%, which is a lot, obviously, if you're the shareholder, but they might make 80% on that. And that's above usury. So in California, for example, if it's not a broker arranged transaction, and usually that's a real estate transaction, you can't charge more than 10% interest. But these are exempt from that. So the brokerages can charge whatever the going rate is. And you can imagine if you're making 80% on lending money, why do you have to sell stock? Just lend out the shares. Just do that. And if nobody is really pressing to evaluate whether there's legitimacy in the short market, why not continue to lend out? So I think of all the areas of brokerages that need to be scrutinized and examined, that should be the share lending process, and there should be some kind of cap on the interest. So brokerages should not be encouraged to lend just to make exorbitant money. That would create a situation where perhaps they might do things that they ordinarily would not do. We've seen many people do that. Probably many of these people are going to watch this, myself, etc., that if you pay somebody enough money, they will do something. So if the brokerage, like Fidelity, if Fidelity is making most of his money lending shares on stocks that are shorted, whether it be legitimate shorts or not legitimate shorts, that has to be scrutinized. And hi there, Busy Brands, by the way. I already talked about you. I hope you weren't listening when I was talking about you. So I really think the share lending program has to be scrutinized. I think the interest rates need to be limited. There should be a cap, perhaps, on the amount of share lending that can occur. And what happens if there's a problem? What happens if they lend shares and they obviously, as we've seen in life, there are circumstances that aren't foreseen. So what happens if there's a collapse, and there's a collapse of the share lending market, and these brokerages are wholly dependent on the share lending to survive. What would happen then? And obviously, there's always circumstances that we cannot predict that might impact that. So I think for the benefit of all concerned, share lending should be attacked and should be limited. And I hope that next Congress or the president or whoever else has power passes regulations or law to restrict that and restrict shorting. As I said, I don't think shorting should be permitted in any type of medical stock or related. And I think in general, it would be nice to have a brief respite from shorting. So if we, as other countries have tried, you could put a prohibition on shorting for 3 months, 6 months, just see what happens. Maybe it would be an improvement, maybe not. Maybe there would be things learned. Maybe there would be limitations imposed. But I think it would be a worthwhile effort to see how the market would work without shorting for a period of time. And let's see what happens. Again, I don't know if all the shorting is improper. Maybe okay. I mean, it may be the case that all shorting's proper, but I don't think it's healthy for the market. It certainly isn't healthy for retail shareholders. It certainly isn't. It's the problem is that retail shareholders get the short end of the string. They get information last. They have no real power individually. And that's why these groups, these proceedings, these videos, all the spaces, what everybody's doing is great because it educates people, it gives them information. They can make their own decisions about all this stuff. But again, I don't draw necessarily conclusions about individual actions being improper. I just think for the benefit of the market and for all of us, it would be better if there was less shorting, if there was more transparency, if there was less share lending, if regulators were cut off from working with Wall Street. I mean, there's no reason why a regulator should be permitted to go work at Goldman Sachs. There should be no reason, and I'm just using Goldman Sachs as an example. There should be some division between the regulators and the financial companies. And whether that is just put a time frame by which you can't go from one to the other. For example, if you work as a regulator, you can't work for a financial industry company for 3 years, and maybe vice versa. If you work for a financial company, so if you work from Goldman Sachs, you can't go to the SEC. You have to wait a period. So it has to be like a gap in time. So we know that you're legitimate and you're not being moved to protect one side or the other. Because there is concern, an obvious concern, that people that work for the regulators are trying to get jobs, better jobs, higher paying jobs in the financial industry, and therefore they have a conflict. How could they rule against companies in which they're going to work or which they want to work? It's a real concern. Anyway, so I hope that there is some kind of division that is put in place to correct that deficiency, because there needs to be a wall between regulators and the financial industry. And that, in my opinion, that would be the biggest thing to benefit shareholders, retail shareholders. If we knew that regulators were on the up and up and were appropriately governing the system without regard to what their future jobs were, then we would be in a much better position. And as Brett Montgomery says, that is called, I think it's called regulatory capture. I think he talked about his deep capture was his story, I think. But he was talking about regulatory capture. You're correct, that the regulators are bound. And you got to think about it this way also. If you're working for the SEC, no matter what job you are, unless you're at the very top, you're making a government salary. Government salary doesn't compare to a private industry salary. It may be the case you're working in the government at the SEC in an important position, making up numbers. But let's say you're making $80,000 a year. You could then go work at Goldman Sachs, being an agent dealing with regulators, and make 5 times that amount of money. And it relates, what it makes me think about is Alpine, where they chose, and this kind of like drove me over the cliff with Alpine. They chose in Alpine a convicted sex offender to be their point person, literally their point, I call them their point man, but their point person with regulators. This was the person that Alpine decided that was the appropriate person to deal with regulators. I was astonished and offended when I heard that, and for various reasons. One, that's who Alpine thought was best suited to deal with regulators. That's one. But two, that Alpine itself thought it was appropriate to have someone working for them that was an admitted sex offender. This is Alpine. Incredible. And there was no scrutiny of that other than the fact at one point in time, Alpine tried to get this individual appointed to be their designated representative dealing with regulators. So this person had been acting as a representative, but they tried to get him as a designated representative. So it wasn't a case where they didn't know, because that was the issue. His prior record came up to be an issue. Yeah, Pat Byrne, just getting on to, I saw a comment also about Pat Byrne needing bodyguards. Yeah, he said there have been physical threats. I know Ham, by the way, I've spoken to Ham. He's talked about having physical threats. People have come, in the past have come to his house. There's enough money involved. I've talked to people. People have had many conversations. There's billions of dollars involved. Whether someone might take action against somebody they thought a threat to those billions, I think definitely the case. So it doesn't surprise me at all that somebody might have been. Yeah, Matthew Iverson is the gentleman, by the way. Thank you for putting that out, Brett. But there is concern that people might pay to have individuals removed who are obstacles to their goals. And so I'm sure it happened to Patrick Byrne and all the current people that are pushing. There may be actions to interact with those people also. Of course, I've thought of it too, but I figured, if you go public, you go very public about what's going on, it's harder to do anything to you. So that's why I try to be transparent about what I'm doing. Everybody knows. And so if anything happens to me out there, you'll know. We talked about it. But it is a real concern. Obviously, I think the FBI, the Secret Service, to the extent there's threats made on people's lives, they should go after them. The fact that Devin Nunes is going after them is a interesting move because I would guess he doesn't feel threatened and he's very protected. So as a result, he's somebody that might be able to take a much more aggressive stand, and he has taken a very aggressive stand, and I'm hoping that he's successful. Whether I like him or not is irrelevant. I like what he's doing now, and I support what he's doing now, and it's for our benefit, I think. I hope he's very successful. I know Busy Brands is worth a chicken nugget meal sometimes on a good day, only on a good day. On a bad day, nah, not worth that. If there's no other questions, I've kept you for an hour. Didn't think I was going to last that long, but kind of summarized a bunch of stuff. If you have questions after you think about this or anything that comes up, feel free to put it out there. Otherwise, to all you out there, anybody who watched this at this late hour, I appreciate it. I enjoyed spending the time with you. And again, if you have questions, put them out there. Look forward to seeing you soon on another video or another live stream. Take care. Everybody be well. Watch what's going on. Support everybody. Good luck. And hopefully we'll get this done. And again, everybody have a great night. Be well. Take care. And see you later.